Good morning, I'm Tyne Morgan, coming to you from our Farm Journal studios in Kansas City. Clinton's on vacation. Well, there's been a ruling from the U.S. Supreme Court that will have implications nationwide when it comes to water and farms. The High Court siding with an Idaho couple in its battle against the EPA over the waters of the U.S. rule. Ag Day's Michelle Rook joins us now. Michelle, what does this decision mean for agriculture?
Ted, the Supreme Court ruling against EPA is a huge win for farmers and ranchers. Not only does it set a precedent, but it has national implications for agriculture, water quality, and development. It also sets the Biden administration back to the drawing board in terms of writing their new WOTUS rule. The case began when Michael and Chantel Sackett purchased a vacant lot in a residential subdivision in Idaho in 2004. They acquired the necessary county permits to develop the site, but the EPA argued that the land was subject to its review because it contained wetlands about 300 feet from Priest Lake. The case focused on the interpretation of the 1972 Clean Water Act and asked for a clearer definition of what the law intended by giving the EPA the authority to regulate the waters of the United States.
In a 9-0 opinion from the court, we got not only a court that found in favor of the Sackett family, but that unanimously ruled that the significant nexus test is not a test that can be used by EPA and the Army Corps of Engineers to determine which features are federally jurisdictional under the Clean Water Act.
This ruling overturns an earlier decision by a federal appeals court that had supported the EPA. Hart says it's a game changer in regards to the writing of the new waters of the U.S. rule, as the court agreed EPA was clearly overstepping its authority.
So I think there's certainly going to be a requirement on the Biden administration to, at a minimum, pull that rule back for some significant revisions. A majority of the court adopted a test called the significant surface connection test, which means that a feature isn't jurisdictional unless it has a continuous surface connection to downstream traditional navigable waters. That's significantly going to narrow the number and type of features that are subject to Clean Water Act permitting requirements.
The preliminary injunction on the Biden administration's WOTUS rule will stay in effect in 26 states. She says in the meantime, it's not likely EPA will enforce their new rule in the other 24 states. Hart also says the decision signals the Supreme Court wants Congress to do its job in passing legislation to govern the regulations tied to the Clean Water Act. I'm Michelle Rook reporting for Ag Day.
Thanks, Michelle. And the American Farm Bureau Federation releasing a statement about the decision. President Zippy Duvall saying, quote, the justices respect private property rights. It's now time for the Biden administration to do the same and rewrite the waters of the United States rule. Farmers and ranchers share the goal of protecting the resources they're entrusted with, but they deserve a rule that provides clarity and doesn't require a team of attorneys to properly care for their land, end quote. For more reaction to the Supreme Court's decision, make sure to check out agweb.com.